Welcome to Early Returns, hosted by Jan Baran, a partner of Holtzman Vogel. This podcast examines law and politics and seeks insights from political players in elections, lobbying, media, and the law. Now, let's join our host, Jan Baran.
Welcome back to Early Returns, a podcast about law and politics. I'm your host, Jan Baran. Our producer is Jody Mayer Piazza. Today's topic is redistricting. That's the apportionment by population of districts for the U.S. House of Representatives. There are 435 House districts, which is the number of representatives in the House. All but 6 districts are subject to redistricting. The 6 that are spared are states in which the population is so small that there's only one district. Those 6 states, by the way, are Vermont, Delaware, Wyoming, North Dakota, South Dakota, and Alaska. All the other states have at least 2 congressional districts, and the most districts are in California, which is the most populous state. Redistricting is supposed to be a once-a-decade exercise by state legislatures. Until the 1960s, the Supreme Court stayed away from redistricting, because the court did not want to get involved in what it called the political thicket. Gerrymandering was left to the political process, not the courts. Well, that all changed, and the Supreme Court started to review redistricting plans to determine what and where and whether they were constitutional. Another change is that redistricting now occurs more than once per decade, as several states decided to revise their district lines. So why is this happening? What's going on with redistricting? To discuss and answer those questions, I have 2 redistricting legal experts. One is Richard Pildes. He's professor of law at the New York University School of Law, NYU. Rick has handled several redistricting cases, including before the Supreme Court. He was the legal advisor to the Obama and Biden election campaigns, as well as a member of President Biden's commission on the Supreme Court. My other guest is my law partner, Jason Torchinsky of the Holtzman Vogel law firm. Jason, like Rick, has litigated redistricting cases, and most recently was a counsel in a Supreme Court case involving the Louisiana redistricting plan. Rick and Jason, thank you both for joining the show.
Thanks for
Very happy to be here.
Well, let's get the ball started here. I'd like to provide a little background, as I just did, but flesh it out a little more and then get into what's going on today. So let's start with what Coach Lombardi used to call the football, to explain football. Redistricting, where did that come from? Isn't that from the Constitution, Rick? And, what's that all about?
Well, the Constitution requires a census every decade, and Congress then has to decide, based on the census, how many representatives to Congress each state gets. States had a lot of discretion about how they would elect those representatives for a long time. Then in 1842, Congress passed a statute requiring all states to use single-member districts to elect their representatives. Then the question arises, who designs these districts? How often are they designed, or how often are they changed?
Let me ask you, I didn't know this. So before the 1840s, you had states that the legislatures would say, okay, Joe Smith and Jack Johnson are the representatives from our district. We entitled it to?
No, what happened before 1842, it's actually, I think it's a very fun and interesting story. The Constitution doesn't say anything about how states elect their members of Congress. So some states would use what are called at-large systems, in which all the representatives would be elected on a statewide basis. So the same majority could control all those seats. Some states would use individual districts. So states that were larger and more heterogeneous, like Pennsylvania, wanted to use individual districts so that different constituencies and different communities could be represented. Smaller states might elect everybody at large. But this was a really inherently unstable structure, because it meant small states, if they all elected people from one party, would have much more influence than a large state, which might be 5-4 party-wise from the individual districts. So the dynamic was kind of driving states to use at-large elections even when they didn't want to. So when Congress stepped in and created a uniform rule in 1842 that all states must use single-member districts, that's when we got the system that we still use today.
Okay. And what did states do or other people do in challenging any of the redistricting results until the 1960s? Were there court cases before then?
Well, so part of what happened is that as we had the great migration of voters to cities, both with World War I and then with World War II, these existing districts often became very unbalanced in population terms. So districts that were centered on urban areas got larger and larger and larger in terms of the number of people. Rural areas didn't increase nearly as much. And most of these state legislatures were designed in a way that gave extra representation to rural areas if you just used an equal population kind of figure. And then as this pattern developed in the 20th century, a lot of states just simply did not redistrict after a new census. And that's partly because, the existing legislators are elected under the existing structure, and they were favored by the existing system, and they weren't about to change that system to reflect the realities of how dramatically these urban centers were increasing in population, whether it's Chicago, Detroit, St. Louis, or other cities. So there were efforts made in federal court and state court to get the courts involved to require these states to redistrict. In many of these cases, state constitutions required them to redistrict every 10 years, but they didn't do it anyway. And in the 1940s, the first case that went to the Supreme Court challenging the great population disparities that had arisen in Illinois between Chicago and downstate rural areas, a case called Colgrove versus Green. Colgrove was actually a political science professor who brought the case, mid-1940s, right after World War II. The Supreme Court, I think it was a 4-3-1 decision, said this is not something the federal court should get involved in. Justice Frankfurter, very famously in this opinion, talked about the way in which getting involved for the courts would compromise the perception of their impartiality, that they would inevitably be embroiled in partisan political conflicts, that the court should reserve its capital for cases more kind of appropriate for the courts to address. And so the federal courts were closed to these claims throughout the 20th century, up until the 1960s. And many state courts followed this Colgrove versus Green decision from the Supreme Court in the 1940s and also said state courts shouldn't get involved in this. So you had this system that, over time in the 20th century became more and more and more imbalanced in population differences, to the point that there were incredibly extreme differences. So at the state legislative level, in a place like Nevada, you had one Senate district that would have 568 people and another one that would have 127,000 people. And they each had equal representation.
And that's at the state legislative level, right?
Right. But the same thing was going on with Congress. I don't think we have an example quite that extreme. But you had population disparities on the order of 45-1 across districts, each one electing a person to Congress.
So the Supreme Court finally decided it was going to ignore Justice Frankfurter and enter the political thicket on the basis of the Constitution, fundamentally because I assume of the Equal Protection Clause, requires that these districts at least have equal numbers of voters or people, so that you would have what's called the one person, one vote principle that was established. Am I correct on that?
Yes. So it's very interesting. When the Supreme Court finally decided it needed to address this issue, it initially just simply said, yes, the federal courts are open to hearing these claims, that disparities can violate the Equal Protection Clause. And it wasn't clear what the standard would be for what a state had to do to have districts that met the constitutional requirements of equal protection. And there were real differences among the court. But fairly quickly, the court gravitated to the view, or at least the majority of the court, that the Equal Protection Clause of the 14th Amendment required essentially equal population for congressional districts. So that's when we get the one vote, one person idea. And actually, that is really the most radical decision the Supreme Court ever decided, or the decision that was the most disruptive of the status quo. Most people think, Brown versus the Board of Education was the most dramatic decision of the court. But I think it's quite plausible to argue that these reapportionment decisions were actually much more disruptive or much more radical because what they meant was that every state legislature in the United States had to be restructured. And it meant that state legislatures couldn't have a state Senate that was modeled on the U.S. Senate, where representation was based on geographical units like counties as opposed to persons. And so it really required every state legislature in the United States to restructure itself, and it dramatically changed the way congressional districts were structured. And this goes to your opening question. Once the court established that the Constitution required equal population in these districts, every time we have a new census, it reveals that the districts are no longer, in compliance with that principle, because over the decade, people have moved in and out. So redistricting is now constitutionally required every decade after the census.
And this applies not just to state legislatures, but also to congressional districts. Am I correct?
And the city council districts.
Oh,
and
everybody.
Everybody.
Every
elected representative body.
Personally, that when I was in law school, it was almost back when Herbert Hoover was president, but the only election law cases that existed when I was in law school were redistricting cases. Baker versus Carr, which was kind of a seminal case, actually came out of Tennessee, where I was at Vanderbilt Law School at the time. So this whole topic is really kind of the beginning of many aspects of what we today call election law or political law. And we've now established what the fundamental basis is that required one man, one vote and equal protection. But everything seems to have gotten even more complicated just a few years later. A handful of years later, Congress passed the Voting Rights Act of 1965. And Jason, what did that do to redistricting?
Made it very different. So switching directly to the Voting Rights Act of 1965 and its impact on redistricting, there were really two portions of the Voting Rights Act that affected redistricting. The first was Section 5, and it's really actually Section 4 and Section 5. Section 5 is a provision that says, basically, if you're covered by Section 5 and you want to make any change in your voting practices or procedures, you need to come to the federal government for pre-approval. And that is either a 3-judge federal court sitting in D.C. or the Attorney General of the United States. There were, from 1965 forward until about 2015, there were all or part of 17 states that were covered under Section 5. And basically, this was a reaction to the civil rights era where a court would say, okay, you can't do A. And the state would say, well, we've changed it. So now we're not quite doing A, but still what the judge intended to say you couldn't do was really being done. It was an attempt to stop those sort of tweaks around the edges to get around specific court injunctions in these states. So
racial discrimination was important here, wasn't it?
Yeah.
And the tweaking and so forth was prohibited because it was perceived as discriminating against races, Black Americans in particular. So they had to have pre-approval before a state or jurisdiction that was changing its districts would have to get pre-approval if they were a state covered under the Voting Rights Act. Not all states were covered.
And this is where it became an issue. Section 5 affected everything from literally, I want to move the polling place from the elementary school to the fire station across the street, to redistricting, to annexations, to changing the size of your city council or your county commission, all the way up to and including, redistricting of your congressional districts. Section 5 was heavily litigated from 1965 till 2015 when the Supreme Court invalidated. It actually didn't invalidate Section 5. It invalidated the coverage formula that was found in Section 4. The coverage formula uses a formula based on census data from the 1960s to determine which states were covered and which states were not covered. And the Supreme Court said, relying on that same formula 65 years later, or 55 years later is no good. And so Congress, you have an opportunity to go back and create a new coverage formula. And Congress has not yet, in the decade plus since Shelby County was decided, the court has not gone back and actually redone, or Congress has not gone back and redone a coverage formula. So Section 5 still exists. There is a provision in Section 5 that allows courts to order jurisdictions under Section 5 preclearance. Happens very rarely. But Section 5 still does exist, and there can be court orders to order jurisdictions back under Section 5. So right now, Section 5 is not a thing, but here's where it impacted redistricting over the years. In the 1980s and into the early 1990s, there was essentially an alliance of sorts between minority advocates and Republicans to try to create as many majority-minority districts around the country as they could. And the reason was when you created a new majority minority district, what you found was the district tended to be surrounded by Republican districts, to the point where in the early 1990s, the Bush 41 administration's Justice Department pursued what came to be referred to as the Black Max strategy. So if you submitted a districting plan and the Justice Department could draw an additional majority minority district that you, the jurisdiction, didn't draw, they would reject your map until you go back and try again to try to maximize the number of majority minority districts. The Supreme Court eventually struck that down in the late 90s and basically said you can't do that because what it resulted in were districts that looked utterly ridiculous and had ridiculous shapes on the basis of race. So
does the shape of a district matter constitutionally? I mean, why is that significant?
So the shape mattered because these bizarre shapes could be an indication to the court that it was drawn on the basis of race, which was prohibited. So think about the classic one is this North Carolina district that stretched literally down like the median of an interstate highway to connect two black neighborhoods or two black areas of a district. And the court was like, the district basically looked like a barbell. It literally went down the median of an interstate highway. And the court said, no, you can't do that. So that's what we had with Section 5. Section 2, on the other hand, had some litigation and some legislative changes, but it basically, by the early 80s, the Supreme Court decided a case called Thornburg versus Jingles. And in Thornburg versus Jingles, the Supreme Court set out a 3-part test for when Section 2, which essentially prohibits discrimination in sort of voting, when Section 2 would require you to draw an additional majority-minority district. And the pieces of it were basically, one, you had to show that you could draw a majority-minority district. You had to show that there was racially polarized voting. And essentially, you had to show that there was sort of the totality of the circumstances, and there were lots of debates about what that meant, it essentially required you to draw this additional majority-minority district. So here's where legislators until this summer with Callais, or this spring with Callais had, was essentially you had Section 2, which told you when you had to draw an additional majority-minority district. And then you had the 14th Amendment back from kind of the Section 5 days, where if you were sort of too race conscious, you violated the 14th Amendment. So legislators for many years under the Voting Rights Act had to sort of, kind of take a bowling analogy. They had to bowl a strike right down the middle, because if they veered too far one way, Section 2 dinged them and told them they had to draw an additional majority-minority district. And if they drew too many majority-minority districts that resulted in ridiculous shapes and were on the basis of race without a Section 2 justification, then they hit the other side of the bowling aisle and they were told that they violated the 14th Amendment. So for a very long time, the Voting Rights Act had legislators dealing with Section 5, Section 2, and the 14th Amendment, all trying to figure out how they were supposed to draw districts under these basically 3 sets of rules.
Can I just add one thing to that story?
Yes.
So 1982, Jason didn't mention this specifically, Congress significantly amended the Voting Rights Act and amended Section 2 of the Act, which applies nationwide. And before that, Section 2 had not been all that significant in litigation because it basically just tracked the Constitution. In 1982, that's when Congress amended the Act to create what we call the results test, that said that voting practices, including redistricting, that resulted in an unequal opportunity for minority groups to elect their preferred candidates, that would violate the Act. That radically changed redistricting. And so what we see in the 1990s for the first time is the real transformation of the redistricting process under the aegis of Section 2 of the Voting Rights Act. And so what you get in a lot of southern states is the creation for the first time of majority black election districts in the face of racially polarized voting patterns of the South, in which the white majority consistently votes in opposition to the preferences of the black minority. And so when that minority is concentrated to be a majority in an election district, it has control of the outcome. And what that produced in the 1990s was the election to Congress of Black representatives from the South for the first time since Reconstruction. So there was a dramatic change starting in the 1990s from the amended Section 2 of the Voting Rights Act. And then, as Jason said, the Supreme Court, put certain constraints on that process, but didn't fundamentally kind of change that process. And so that, starting in the 1990s, we get the creation of these, we can call them VRA districts or opportunity districts, which initially were majority African-American, but then over time, as it turned out that Black voters could elect their preferred candidates with less than a majority of the electorate because of support of white voters, those districts became to be called ability to elect districts. And Section 2 of the Voting Rights Act required the creation of these ability to elect districts for minority voters. Eventually, it includes Hispanic and Asian voters, though the paradigm initially is race, in which these ability to elect districts were created throughout the country, mainly as a result of Section 2 of the Voting Rights Act, until the most recent Supreme Court case.
Very interesting. I admit I've always found it very confusing to understand what the heck was going on in redistricting. As a lawyer, and specialized in election law, I had to go to people like you to explain what the heck does this mean. But your explanation was very interesting to me because it sounds like what Section 2, as modified in 1982, did is it basically promoted racially required gerrymandering.
It did. Now, what's really interesting to me is over time, districts, if you think about the Congressional Black Caucus, right now, something like only 25% of the Congressional Black Caucus that's currently sitting in Congress comes from a majority-minority district. There was a time where 100% of the Congressional Black Caucus came from majority-minority districts. So, voting patterns have changed over time, I think in a good way. And I think the racially polarized voting and the geographic concentrations of minority voters are not what they were in the 1960s. And I think that's progress for the country. But again, I think people are sort of under the impression that some people are under the impression that African-American candidates can only win in majority African-American districts. That's not true anymore. It used to be true. It's really not true anymore.
It's not true to the same extent, that's right. But a lot of those districts that are not majority African-American districts were still created under the compulsion of the Voting Rights Act. So in the absence of Section 2, those districts might not exist, even if they're a 45% Black district or a 42% Black district that has been electing African-American candidates that are the preference of the African-American community.
So if I understand further, you experts have to explain this to me, but if you have a majority-minority district that wasn't originally required to comply with Section 2, and a state legislature gets a census and has to redistrict, and they, for whatever reason, dilute this majority-minority district, would they then be under the traditional interpretation of Section 2 be in violation of Section 2?
So it depends. I'll give you a great example.
Did I hear Rick say yes?
Go ahead. I'll let Jason speak and then I'll answer it.
I think it depends. For a while, you had both Section 5 and Section 2 to contend with. So I actually represented the Louisiana House of Representatives in 2011, which was the first redistricting post-Katrina. And, we had a situation where something like 350,000 people moved from the greater Orleans area, mostly to elsewhere in the state. So when we were districting, we had districts where, a state house district around Orleans that should have had 42,000 people or so as an ideal population had 17,000 people. So we were ultimately, the legislature, the state house in Louisiana was able to actually increase the number of majority-minority districts by 1, but they were in dramatically different areas of the state. You couldn't maintain the same number of African-American majority districts around Orleans because the population simply wasn't there.
Well, that sounds like an unusual circumstance where you had a dispersal of a population. How about other predominantly African-American communities in other southern states which have retained their composition racially, or a majority-minority district? of black voters. Are they safe? Do they have to remain minority?
So if you're asking under the traditional view of Section 2 before the Supreme Court decision this spring, the answer would be that if there's racially polarized voting and if the minority community has cohesive political preferences and minority candidates are not being elected to a significant extent, then the state has an obligation to create what we called ability to elect districts. They didn't have to be majority minority, but they had to give this equal opportunity to elect candidates that the minority community preferred. And maybe this is getting too far ahead of the story, but in the 2010 round of redistricting, Republicans, for the first time since Reconstruction, were in control of the process in southern states. And in a number of those states, they took positions that the Voting Rights Act required them to, I would say, pack black voters into districts at rates that were not necessary, actually, to provide the ability to elect. So in a case I argued before the Supreme Court in 2014 out of Alabama, the Alabama legislature had said, well, we think the VRA requires us to keep the black populations at exactly the same levels they had before redistricting. So that meant if a district had become 70% black, they said, well, we have to maintain it at 70% black. But that was way in excess of anything necessary, even in the face of polarized voting, to provide this equal opportunity for the minority voters in Alabama to elect their preferred candidates. So in the case I argued, the Supreme Court said the Constitution is violated if states pack black voters into districts at levels that are excessive and unjustified, meaning the Voting Rights Act couldn't require this. And one of the things you don't hear nearly as much about in the press, but the Supreme Court actually struck down Republican-generated redistricting maps in the 2010 round of redistricting from Alabama, Virginia, and North Carolina, because those legislatures, in the court's view, had used race in excessive ways, way beyond what the Voting Rights Act actually required.
Jason, I'll let you jump in here, but just so I, again, understand, the Voting Rights Act, as then interpreted by the Supreme Court, was violated when legislatures put in too many African-American voters in the same district. Is that correct?
Not the Voting Rights Act was violated. The 14th Amendment was violated.
Which is equal protection again?
Which is equal protection.
Okay, so it was violated because there were too many minority voters in a district?
That's right. So the structure of the doctrine, Jan, just to help clear it up for you, was that if a state is using race as the predominant factor in moving people in and out of districts, it has to meet strict scrutiny. The justification that the court had accepted to meet strict scrutiny, or at least had assumed was acceptable justification, was complying with the Voting Rights Act. If the Voting Rights Act required this, then you had a defense under strict scrutiny. But if you were packing black voters in at levels that the Voting Rights Act did not sort of plausibly require, then you don't have a defense under strict scrutiny to what you've done, and you violated the 14th Amendment. That was the structure of the law in the 2010 round of redistricting, or that emerged in the 2010 round, starting with the Alabama case that I argued successfully.
That may be a good point to segue to what happened since that time, after the 2020 redistricting, right? Which brings us to today, theoretically. And that issue that you just described seems to have been involved in the recent Louisiana case that involved Jason, not the other Louisiana case, but the current Louisiana, called Callais, right? So what did the Supreme Court change as a result of the Callais case?
Let me just step back and give you a little bit of the history of Callais and Louisiana. So in the 1990s, when Louisiana had 7 congressional districts, Louisiana tried 3 times to draw a second majority-minority district. They had the traditional, as I described, congressional majority-minority congressional district around Orleans, and they tried 3 times to draw a second that tried to unify black population that was spread around in other parts of the state. And 3 times, like I mentioned, when the courts looked at the shapes of the districts, they said these are unconstitutional racial gerrymanders. So in by 2001, the state went, by the late 90s, the state had gone back to the traditional single majority-minority district around Orleans. kept that in place in 2001. Then you had the population shift in Louisiana in 2007 that I described following Hurricane Katrina. So in order to maintain the majority-minority district that they had, and by the way, the state had dropped back to 6 congressional districts at this point, they basically unified the African-American community in Orleans and in part of Baton Rouge, kind of following the snake-like shape of the Mississippi River to connect Baton Rouge and Orleans, because there simply wasn't enough population, particularly enough African-American population left in Orleans to make a majority-minority district. So that Orleans Baton Rouge district was what was adopted in 2011. In 2022, when the census data came out for 2020, you had a situation where you had a Republican legislature and a Democratic governor. The Democratic governor said, we need a second majority-minority district in Louisiana's congressional districts. And the legislature said, no, we don't. We should have one. And they overrode the governor's veto of the map, and they reenacted basically a map that looked very similar to the map that they had in 2011. They were immediately sued in the Middle District of Louisiana, and a district judge in the Middle District said, yep, you have to draw a second majority-minority district because all of these jingles requirements are met, and you have to draw it. So the state went up, appealed at the Fifth Circuit.
Let me just add, this is very good and very helpful to me, but just to understand what the district court did at this stage, they said you have to draw a second African-American majority district because Section 2 required it?
Correct. The Middle District told the state Section 2 required it.
They had to draw up 2 opportunity districts.
Yes.
Right, which don't have to be majority black.
Well,
correct.
They just have to provide the ability
okay.
to elect. There's no debate about that. I mean, that's clearly what the law is. They only have to create an ability to elect district under Section 2. They don't have to draw a majority black district. The Supreme Court's made that very clear.
Okay. So the Middle District of Louisiana told Louisiana they had to draw a second black district. The decision was stayed and the case was paused pending the other Alabama case, the decade later, the Rick's Alabama case was sort of pending. The case went through the Supreme Court, did not upend the district court decision out of Alabama. The Supreme Court sent the Louisiana case back down for basically remedial proceedings. And by this time, Louisiana had a Republican governor who had been the attorney general and still a Republican legislature. And the governor said, great, I'm going to call the legislature into special session. We're going to draw a new district. So they called the legislature into special session, and the legislature drew a second majority-minority district.
So this is the second meeting of the legislature to draw another map.
Yes.
In the same decade, right?
Same decade, subject to the court order. So the state said, great, we're going to draw a second majority-minority district. So they kept, a bunch of the Orleans, Baton Rouge shape. And then, there isn't enough African-American population in Southeast Louisiana to draw a second district there, no matter whose map you looked at. So you had to get more African-American population somewhere else. And so you either needed to go up to Monroe, which is what the plaintiffs in the case wanted, or you had to go to Shreveport, which is what the legislature did. So it created this district that looked like a backslash down the center of the state. Within a week of the governor signing that second majority-minority district, the state was sued in the Western District of Louisiana, and now we had a 3-judge court in the Western District of Louisiana alleging that the map with the second majority-minority district was a racial gerrymander. It was an unconstitutional racial gerrymander under the 14th Amendment. After an expedited proceeding in April of 2024, the 3-judge court in the Western District of Louisiana issued an opinion saying drawing the second majority-minority district was an unconstitutional racial gerrymander. So now you're the state and you're like, I drew 1 and a federal court told me no. And now I drew 2 and a federal court told me no.
Let me interject here. If anybody's still listening at this point, since we're so deep in the weeds, but to win their case, to prove that the state under the Voting Rights Act had an obligation to create a second VRA district, the plaintiffs identified a region of the state, as Jason was mentioning, which was basically in the northeast part of the state, where a second reasonably compact VRA district could have been drawn. The legislature didn't want to draw the district there for political reasons. They wanted to protect the Republican incumbent up there, and they wanted to screw a Republican incumbent who was kind of on the outs with the legislature, partly because he had opposed Steve Scalise in the House leadership contests and for other reasons. So the Voting Rights Act didn't require them to draw this highly contorted district. The Voting Rights Act required them to draw a reasonably compact district, which they could have drawn. They just refused to do that for political and incumbent reasons. That's why they ended up with a district that the courts then said violates the Constitution.
All right. So you have two district courts in Louisiana coming up with two different solutions to a problem of whether or not to have a second district that could be racially representative of the community down there. And you, Rick, are also observing that part of the legislative decision-making here was not necessarily racial decision-making. It was to protect an incumbent who, I understand, may have been the Speaker of the House of Representatives as well. I don't know if it was that district.
No, it wasn't that.
They had partisan political reasons to devise the districts the way that they devised them, even with the two districts, right? So all of this mess comes up to the Supreme Court. And what does the Supreme Court do?
Well, if you want me to start that discussion off. So basically, the Supreme Court decision in Callais was teed up last term before the court. It was argued. And then the court said, we want to have re-argument in the case because the court clearly wanted to consider very, very large issues that hadn't been fully kind of briefed in the initial round. So this term, the case was re-argued, rebriefed. By the way, you now had a change of administration. So you had the Solicitor General of the United States coming in on behalf of Louisiana in this case. And in the opinion by Justice Alito, we could talk about a lot of the details, but, fundamentally, the opinion redefines what makes a violation under Section 2 in such a way that Section 2, I think, will have almost no practical impact anymore. I think the decision really neuters Section 2 for most practical purposes. I think there were things that had changed since the Supreme Court created this framework in 1986 in this Thornburg versus Jingles case that Jason mentioned. And there are various ways the court might have modified that framework to an extent to take those changes into account. There were a number of ways of doing that had been proposed, but the court went much, much farther than that and adopted a way of applied Section 2 that I think most people who study this believe really eviscerates it and makes it almost of no practical significance.
That's the result.
Right.
Now, part of the explanation for the outcome, if I understand it correctly, is that the court distinguished racial motivations in contrast to whether or not redistricting is motivated by partisan considerations. And this whole issue of can it be unconstitutional to redistrict using just partisan motivations? That's something you're quite familiar with, Rick, because that's an issue that you were involved in, again, at the Supreme Court. And just to speed up the whole timeline for our listeners a little bit, that in 1986, I think, the Supreme Court said it's possible that partisan motivation could be unconstitutional, although they were unable to identify a single instance of it whenever a case came up to it. And that brings us to the Ruccio case, or Ruccio?
Ruccio, yeah.
Yeah, which was, what, in 2018 or 20?
I think roughly 2017, 2018. Yeah.
There you go. All right.
Yeah.
Yes. And this was a case where the allegation was that some redistricting in Arizona was unconstitutionally partisan. What happened?
Right. Well, they actually had two cases before them. One was from North Carolina, which was a Republican partisan gerrymander. One was from Maryland, which was a Democratic partisan gerrymander. And as you said, the Supreme Court in the mid-'80s had held that partisan gerrymandering could violate the Constitution, but they had never struck down a plan as an unconstitutional partisan gerrymander. The case out of North Carolina, so I represented Common Cause in this case, Common Cause versus Redistricting. In the case out of North Carolina, you had statements from the Republican legislatures who were leading the redistricting process, the chairs of the committees, saying things like, well, we've drawn the map the way we have because we couldn't figure out how to create one more Republican district. Or we think electing Republicans is better than electing Democrats. So that's why we drew these districts in the way we did. There's no question the partisan motivation was explicit. It was, as they said, it was as far as they could figure out how to go in turning what is roughly a purple state, maybe somewhat Republican leaning, but certainly not a deep red state, into a state with an 11-2 congressional delegation. So I have long argued against partisan gerrymandering. I've long wanted constitutional constraints on it. I think it kind of follows in the wake of Baker versus Carr and Reynolds versus Sims, and the court recognizing that one of the problems in democracy inherently is that if those with power have the power to control the election process, there's a risk they will use that power to entrench themselves and their partisan allies more deeply in office in anti-competitive kinds of ways. So I think that's what the court recognized, that idea in the one vote, one person cases. I was hoping the court would recognize the same thing and impose some constraint on partisan gerrymandering. So while I was successful in the Alabama case, we were unsuccessful in the Rucho case, 5-4. And the Supreme Court held that partisan gerrymandering claims are not justiciable in the federal courts, meaning the federal courts are not open to hearing these claims based on the court's conclusion that there aren't appropriate judicial standards to manage this problem, to address the problem.
So they took one step back to the era of Justice Frankfurter. Said,
yes,
we're not going to get into this, right?
I think that's a good way to put it, yes.
Okay, and in fact, I'd like to poll the current Supreme Court to see whether they think they should go all the way back to Justice Frankfurter and stay out of this mess, which they seem to be enthralled with. My reason for fleshing this out with both of you is to explain in terms of the Callais case, the Louisiana case, where you, Rick, have observed the result is that it has arguably really diluted the effectiveness of Section 2 of the Voting Rights Act, that the justification in the case in part was that really the motivation in Louisiana, just like the motivation in North Carolina that you just described, was partisan. It was not racial discrimination. It was partisan motivations. So that seems to change the whole redistricting ballgame quite a bit. If that's no longer, if partisan redistricting is no longer unconstitutional, and if it can mask racial discrimination, or at least arguably substitute for it, then we are in a different ballgame, which seems to be the reason why one of the reasons, there are other reasons, one of the reasons that we are in this era where redistricting is now just going to be a very, very different game.
Yeah. So can I just elaborate a bit on what you said?
Yes.
And to use the example you asked about, under Section 2, the way it had been understood all the way up until this Callais case, what would happen if a state decided we want to get rid of this Voting Rights Act district or this majority black district? And that's exactly what becomes permissible under this Callais decision. So as an example, one of the things that happened in the aftermath was Tennessee decided to take a district that had been based on Memphis, that actually a former student of mine, his father occupied this district for many, many years, Harold Ford. Then
Harold Ford Sr., he was there when I was a law student.
Right. And then Harold Ford Jr., who was my student at Michigan Law School, then ran for the seat and won it and held it for a number of years. And I think he was maybe the second youngest person ever elected to Congress at the time he was elected. In any event, the Tennessee legislature in the immediate aftermath of Callais carved that district up and spread those black voters out around surrounding districts so they no longer were concentrated into an effective opportunity district. And what Callais permits is for the Tennessee legislature to say, we want these districts to be Republican districts. And that effectively overrides the Voting Rights Act claim. So, to go back to Louisiana, for example, Louisiana has 6 districts. If the Republican legislature says we want all 6 of these districts to be Republican-leaning districts, the Voting Rights Act under Section 2 had said, well, you can't do that if you're going to dilute minority voting power. But now that kind of, in a sense, overrides Section 2, or that's a defense to a Section 2 claim. That's why, in my view, Callais kind of really eviscerates Section 2, because if a state can say, we want to make these districts Republican, at least as long as VRA districts are electing Democrats, as they almost all do, I think maybe they all do, I should say, you'll never be able to win a Section 2 claim in a redistricting context if that's an appropriate defense. So that's a really dramatic change.
Yes, it is. And, I think your Tennessee example, which is a good one, is also reflective of the complexity of redistricting results, because the district, which had for decades been represented by either Harold Ford Sr. or Harold Ford Jr., for the last 10 or so years, has been represented by a white Democrat.
Right.
Even though there was a majority Black community in that congressional district, they have elected a white representative.
Yeah, so the VRA didn't require the election of minority candidates. It required, where there was polarized voting, an equal opportunity to elect minority preferred candidates. Now, in most instances, those were minority candidates, but there were a few examples like Steve Cohn from Memphis, the minority community having a strong preference for a white candidate who was then elected from these VRA districts. That's a good example.
So one of the criticisms that Republicans have long had of the Voting Rights Act and the way it's been used and interpreted by courts is that essentially it was used as a ratchet to create more Democrat-leaning districts. And I'll just give you one example. I actually have a cert petition pending in two cases that I'm handling out of Washington State right now. Washington State, and this is the Washington State legislature. They had a commission that draws their districts, and the commission agreed to draw a majority Hispanic citizen voting age population district in the Yakima Valley. The district elected a female Republican Hispanic to the state Senate, and the UCLA Voting Rights Project challenged the district as unlawful under Section 2 and claimed that it unlawfully diluted the votes of Hispanic voters, despite the fact that it elected a Hispanic Republican woman. And after trial, the judge found that it did, and then he issued a remedy that drew it as no longer a majority Hispanic district. So this is literally the testimony was the district elected the wrong kind of Hispanic to the district. I mean, people sat on the witness stand at trial and said she's the wrong kind of Hispanic because she was a Republican Hispanic, not a Democrat Hispanic. And the judge said yes. And so this is the sort of twisting and manipulation of the law that Republicans have long criticized about, kind of how the Voting Rights Act has been interpreted. And I think that message from Republicans broke through to the court, and the court really started to realize how the Voting Rights Act has been manipulated to essentially elect more Democrats.
Here's the way I think about the relationship of the act to partisan politics. So in the 1990s, as we talked about at the very beginning, Republicans actually very much liked the Voting Rights Act because at the time, by creating these VRA districts, it did make surrounding districts more Republicans. And so there was this alliance between Republicans and voting rights groups in the 1990s. And in 2000, I don't think there were big partisan effects. In 2010, Republicans, were in charge of redistricting. And they basically were willing to live with the VRA status quo. And even in 2020 redistricting, they didn't really, in southern states, go after the existing VRA districts. But I do think that over time, as partisan gerrymandering wars got more and more intense, and as control of the House seemed to turn on finer margins, and both sides started trying to squeeze out every additional district they could for their side, Republicans started looking at areas like New England, where Republicans get 40% of the votes, but none of the congressional seats are Republican leaning. And then they come to the South and they say, well, we have control of the process here. Why do we have to create these Democratic leaning districts, in Louisiana or Alabama and the like? And so I do think that the changing nature of partisan competition over districting and the sense that politics has become existential. So who controls the House or the Senate or the White House? The stakes are viewed as so high that I think the partisan effects of the VRA became more of an irritant to Republicans, though they didn't go after these districts in the 2020 round of redistricting. What happened is VRA plaintiffs won additional districts after 2020 in places like Alabama and Louisiana. And that's what triggered these states to then really fight very hard before what they thought rightly would be a sympathetic Supreme Court to kind of push back on all of that. But I think the partisan effects of the act became more more of a real irritant, if that's the right word, more upsetting, more disturbing to Republicans as the partisan gerrymandering wars reached the intense white-hot point they've gotten to.
Yeah, and I agree with Rick on that. And I really do think there were some advocates on the Democratic side who I think pushed the Voting Rights Act claims for partisan advantage in a way that really did cause a backlash from Republicans. And I think despite the fact that certain Democratic lawyers are like, oh my God, the Supreme Court did this, I think you have to put that in the context that Rick just did, which is as the Voting Rights Act was used by certain advocates on the left to push for more Democratic seats, it became a problem for Republicans who wanted to maintain control of the House or even of state legislatures. And I think that's where this kind of came to a head in Callais at the Supreme Court.
Well, this all brings us to the observation that our national politics has become much more polarized and seems to be very narrowly split between the two major parties. And that's contributing to all this intensity that you just described in terms of redistricting. It also seems to have contributed to the activities relating to mid-decade redistricting. Right? Everyone is worried about the upcoming off-year election, and the Republicans want to maximize their seats in Texas, and the Democrats respond by maximizing their seats in California and elsewhere. I did ask Rick before the program, has this ever happened before where there's been redistricting mid-decade? And I understand it has. So when did that happen, Rick?
Yeah, so the last time this happened in a major way was actually out of Texas in the early 2000s. And the context there was the Texas legislature had been divided along party lines at the time of the census and the redistricting. So the federal courts imposed a redistricting plan. Then in subsequent elections, Republicans got full control of the process in Texas. And they said, well, we don't want to live with this court-ordered plan. So they engaged in mid-decade redistricting. In a case that went to the U.S. Supreme Court. And I filed an amicus brief in that case on behalf of myself and two of my academic colleagues at NYU, Sam Zakharoff and Burt Newborn, arguing that even if the court wasn't prepared to take on partisan gerrymandering as a general matter, it should recognize a ban on mid-decade redistricting when not done subject to a court order. And what we were concerned about at that time was that this would set off this terrible spiral in which states would constantly try to improve their margins election cycle to election cycle by engaging in mid-decade redistricting. We thought this was very bad for the democratic process, constantly destabilizing the districts. Voters have enough time understanding who their congressperson is if you're changing their districts every 2 years. And at the time, I thought that what Texas was doing might set that off. It actually didn't. I mean, the Supreme Court rejected the argument, needless to say.
Well, they did another Frankfurter, right? They said, no, we're not going to go. It's not in the Constitution. It's not illegal by statute. I mean,
right. Some state constitutions or some state courts ban it as a matter of state law.
States can change their laws as long as it doesn't violate the Constitution.
Death spiral didn't really happen in the 2000s that I was worried about. And it didn't happen after the 2010 round of redistricting. But it's happened today because it was set off by President Trump pushing the Texas legislature to redraw its districts to squeeze out more Republican seats in a context in which partisan control of the House hangs on a kind of a knife's edge. And that triggered this whole spiral that I had been worried about 20-some years ago that didn't happen, but is actually happening now. And of course, Democrats said, we're not going to sit by, and unilaterally disarm. If Republicans are going to do this, we're going to do it. And I think this is just very bad for the democratic process.
You have the collision of the president's push for the mid-decade redistricting with the Callais decision coming out at the exact same time. And I think it was a perfect storm of opportunity for folks on both sides to really engage in a fight that happened over the last 6 months, and I think is going to continue into the 2028 cycle.
One of the things that's grown out of this, and I kind of want to make sure we wrap up here in time by covering not only redistricting, but also the element of the Supreme Court, which is deciding how to inject itself in these issues, as we just discussed. Are they going to do a Frankfurter, or are they going to do an Earl Warren, right? And really get into this stuff. And so the Supreme Court is controversial. There are discussions and debates about, whether they're doing the right thing and whether they are too partisan. And Rick, you served on President Biden's commission on the Supreme Court that was vested with sort of analyzing that issue even before we got to Callais and the current redistricting disputes, and whether or not to recommend that Congress increase the size of the number of justices on the Supreme Court, which is the power of Congress to make it bigger, make it smaller, more justices, fewer justices. The Constitution doesn't say anything about that. It's up to Congress, right? What did the commission do? And did it come out with any recommendations that might be relevant to our discussion here on redistricting?
Well, so as a starting point, the executive order that created the commission instructed the commission not to make recommendations. And that's actually not an uncommon thing because presidents don't want to be boxed in by their own commissions. What triggered the commission was that, during the Democratic primaries in the run-up to 2020, there was a lot of discussion about this issue of, court packing or expanding the court. And President Biden, or candidate Joe Biden at the time, didn't want to take a position on that. He thought, I think he said during the campaign, I would appoint a commission to study these issues. And our mission was to look at the major reform ideas that are out there about the court, not just to look at court packing, but we looked into adopting the 18-year terms for the justices. We looked into congressional control of the Supreme Court's jurisdiction. We looked into ethics reform concerning the court. It was a large commission, 35 some people. I think many people expected the president to appoint a completely Democratic Party oriented commission. That wasn't the case. The commission was co-chaired by Bob Bauer, who had been White House counsel to President Obama, and Christina Rodriguez, who's now the dean of Yale Law School. And it was intentionally designed to be somewhat bipartisan or somewhat cross-ideological. So what the commission did, and I'm actually quite proud of the commission's work, was to look at all of these major proposals and to go through the issues about them. What's the history behind the issue? What are the pros? What are the cons? What considerations have to be taken into account if reform was going to go in this direction or that direction? So I think I didn't expect anything to happen, in the immediate aftermath of the commission's report, which is like a 300 or 400 page, study of the court. But I do think if we get to moments where court reform is a serious political issue, I think the report will be a kind of a major starting point or a blueprint for discussions if a political window opens up. People on the commission definitely divided, had different views about these various issues. There was not any uniform view about almost any of these issues, even within the commission.
I assume that this commission report is available online somewhere, certainly at the NYU Law Library at the very least.
Well, it used to be on the White House. I haven't looked since President Trump took office, but I know you used to be able to just go to the White House webpage and look for Supreme Court Commission and find it. After this podcast, I'm going to go take a look to see if it's still available there. But it's a public U.S. government document.
Yeah, all right. So, and nothing actually happened after that in terms of any Biden proposals or any proposed legislation, or was there?
Some Democrats have introduced legislation on some of these issues, but it's always been at a very low level so far. But you definitely hear Democrats in the campaign mode talking about court reform needing to be on the table. There are different kinds of reforms that one could talk about.
And when it comes to term limits, as was discussed by the commission, and you mentioned 18 years, currently Supreme Court justices serve for life.
That's correct.
And a term limit, however, would it not, an amendment to the Constitution?
Well, that's a question that academics debate, and that debate is played out in the report. There are some people who think it can be done by statute in various ways. There are some who think it would require a constitutional amendment. There are issues about would it apply to the sitting justices or only to new appointments. There are a lot of, one of the things the commission process generated was a recognition of all the kinds of questions that have to be thought through for any of these kind of proposals. But, I would mention Supreme Court is the only high court in the world in which justices do not have either a mandatory retirement age or a fixed term of office. Life tenure has changed dramatically over the years. So, up till 1970, the average justice served 15 years. Since 1970, we're seeing people stay on the court, getting appointed much younger, staying on the court much longer. So the average length of service has gone way up what it had been historically up until the 1970s or so.
Well, some people would say that there are many aspects of our constitutional system you won't find anywhere else in the world. And that might be a reason to preserve those elements, but that's for another day and another debate. Before we sign off, after this wonderful discussion, in order to wrap up redistricting, I'd like to recognize each of you for a short prognostication of, what to look for going forward in redistricting, between now and let's say the next census, which is only in 2030. I mean, we're only 4 years away from the next census. So let me start with Jason and then Rick.
So I think we're going to be looking at additional legislatures, both Democratic and Republican legislatures, meeting in 2027 to redraw for 2028 where they see opportunities. I think that's quite likely. I think 2030, particularly after the census comes out, all of the population projections show a shift of about 10 or 15 seats from what are traditionally thought of as blue states to what are traditionally thought of as red states. And this will affect not only the U.S. House of Representatives, but also the Electoral College in ways that could be very dramatic for the next decade. So I think that looks like it's coming down the pike in 2030, unless these population shifts that are projected and are kind of underway between states change or reverse, which at least at this point, they don't show any signs of slowing down. Just to give you a quick example, California could lose between 5 and 7 congressional districts because of the population shifts out of California to other states. Democrats losing 5 to 7 electoral votes out of California for the 2032 and 2036 and 2040 presidential elections could be very significant. So I think redistricting and reapportionment, I think, are going to be on people's minds a lot the next couple of years.
And Rick?
Yeah, I think that's right. I think that you're going to see more aggressive partisan gerrymandering still. You might think we've gotten to the end point, but we haven't gotten to the end point. I think these redistricting wars are just going to continue. Each side is going to really maximize its number of seats in states in which it has control. I don't think it's going to be good for voters or for the democratic process or confidence in the process. I do wonder if Congress would consider some significant reform going into the 2030 process. Any reform like that would probably have to have some degree of bipartisan support. You could imagine maybe the Senate gets rid of the filibuster, maybe one side rams through some approach to gerrymandering but I still think it's more likely you would need some degree of bipartisan support. So there are certain reforms that could do that would really significantly reduce the effects of partisan gerrymandering. I don't want to get too far into this, I guess, at the end of a podcast, but there are ways of designing the process through legislation that would significantly reduce partisan gerrymandering and in a way that would neither give one party nor the other any significant advantage. But we can leave discussion of that perhaps for another time.
I don't know what the future would be for proposals that don't give one party or the other a significant advantage. That always seems to be an obstacle in legislation and compromise.
I think a lot of people on both sides recognize that this process has gotten to a point where it's really unhealthy. And so if there are approaches that don't seem to tilt the deck one way or the other, maybe there's some opening for that.
Yeah, well, let's hope so. I say what I said, not to be negative about this, but having seen Congress work for the last 40, 50 years, when it comes to any proposals that really implicate their own reelection, they may complain about the process, but the solutions don't seem to invite bipartisan solutions by and large. Well, let me just thank both of you, Richard Pildes and Jason Torchinsky, for being on Early Returns. I also want to thank our sponsor, the Holtzman Vogel Law Firm, for their support of this program. Any opinions that are expressed here, I have to say each episode that those opinions are those of our host, me, and our guests, and that they do not necessarily reflect the views of our sponsors or their clients. By the way, all of our episodes are available on Buzzsprout as well as other podcast platforms such as Spotify and the National Law Review. I hope you listeners will check them out. And thank you for listening, and I hope you will join us on the next edition of Early Returns. Have a good day.
Thanks for joining Early Returns, Law and Politics with Jan Baran. We hope you will join us for future episodes, which will continue to bring you voices and insights from the people engaged in our political landscape.